would get those cases that were specific to their expertise. But theoretically, they were supposed to solve, push up their sleeves and actually solve the problem. In 1988, Congress liked the idea of the taxpayer ombudsman so much that it actually codified it, put it into the law, the Internal Revenue Code, and described the position. But they still described it as a career civil servant, and it reported down to maybe 2 levels down from the commissioner. By 1996, Congress decided that the taxpayer ombudsman was a weak position and not a strong enough advocate for taxpayers. So they renamed it, okay, whatever. But they renamed it taxpayer advocate. So it sort of retained its ombudsman function of being an intermediary and a neutral. But they said, we want you, once you've decided what you want, what you think is the right answer, we want you to advocate for taxpayers. They also gave that person some power. They created something called, and this had actually been administratively created, but they codified this provision, which was the Taxpayer Assistance Order, which allowed the advocate to order the IRS to not do something, like not levy on a taxpayer's account. And they also put into the law that the taxpayer advocate and the deputy commissioner should submit to Congress a report to talk about the taxpayer service problems that taxpayers have. So then you get, that's 1996. And then you get to the years leading up to between 96 and 98, leading up to something called the Internal Revenue Service Restructuring and Reform Act of 1998, which was a landmark piece of legislation. And there were two years of hearings that preceded the enactment of that legislation. There was a national commission created by Congress that went around the country to hear about the problems that small, medium, large individuals, low-income, high-income taxpayers were having with getting the IRS to resolve their problems. How was the IRS treating taxpayers? And then the House Ways and Means Committee and the Senate Finance Committee held over about a year a series of hearings, and many of them people put bags over their heads and hid behind screens and had their voices digitized to tell their stories. The hearings were very controversial, and I think it's common today to sort of cast them in light of some of the testimony where people told stories that were maybe later disproved. But if you read the hearing record, what you find, it's a remarkable document about the problems of the administration of the Internal Revenue Code. All 5 or 6 of the living past commissioners testified and talked about their experience. All sorts of tax professionals came in and talked about the problems that they see. And by a weird fluke, I was invited to testify before the Ways and Means Committee and later the Senate Finance Committee about the problems that low-income taxpayers had, because I had founded in the United States the first low-income taxpayer clinic, a legal aid society dedicated solely to representing low-income taxpayers with their tax disputes in the IRS. And that came to the attention of Congress through a very roundabout way. And they asked me to testify about the problems that low-income taxpayers were experiencing. And I also sort of threw in what my own clients were experiencing too, because there I was in front of Congress and thought, why waste that opportunity? But they became aware of me in that way, and my testimony did result in several provisions, actually, of the law on taxpayer protections in the collection arena, in the audit arena, and then it also resulted in the enactment of, with another friend of mine who ran an academic clinical program that represented low-income taxpayers, the enactment of a grant program for funding low-income taxpayer clinics throughout the United States. So that was very important in that. what happened to my current office in 1998 is that they addressed several things that caused a lot of people concerns about the structure of the problem resolution officers who were embedded in the IRS and in the management chain of the IRS, the same management chain that were overseeing the people who might be causing the problems that the problem resolution office was supposed to be curing, that there might be a conflict of interest there, and the problem resolution officers may not be as vigorous in speaking up for taxpayers or seeking solutions for taxpayers because their supervisor may retaliate, against them in their performance evaluations and things. And in fact, the commission actually heard testimony about that by one of the problem resolution officers who had been retaliated against by her immediate supervisor for taking a strong position about a taxpayer. I will note that that person is now the Deputy National Taxpayer Advocate. So there you go. But Congress took that to heart and just threw up the cards and redesigned the office. So here's the structure as of 1998. But you have to think about how it got from 1976 to 1998 to where it is today. So the first thing that they did to address the independence of the office, they first talked about making the National Taxpayer Advocate a presidentially appointed position, but they thought that that was making it political, and they didn't want to make it a political office. They wanted to make it a bipartisan office. So then they thought, let's place the office in the Department of Treasury. But the Department of Treasury really doesn't get to see taxpayer account information. You really protect Treasury from that. So if our job is to protect taxpayers and advocate, I need to see all the data and everything. I have to have complete and full access to IRS systems. I need to see what they're writing. I need to see instructions to staff. I need to see guidance. I need to be in on the teams as they're deciding initiatives. So Congress decided that the position needed to be inside the IRS. But the minute you put the position inside the IRS, you really have to think about how you create independence of that position. So the first thing they did was they said that the National Taxpayer Advocate, who will head this office, is not going to be appointed by the Commissioner of the Internal Revenue Service. I am appointed, and when I say I, it's the National Taxpayer Advocate. I am appointed by the Treasury Secretary. And so therefore could be fired by the Treasury Secretary. But my immediate boss, which by law I report to the commissioner on a day-to-day basis, and that gets me inside the IRS, but my boss cannot fire me, which my boss, one of my bosses did in fact attempt to fire me. And you can see that he's no longer here and I am. And the idea was that there would be a safety valve there, that, that saner minds would say, do we really want to do this? What's the issue? Let's have a discussion or whatever. So that keeps you independent in that own way. The second thing that's very important is that the law says that you cannot, that as the National Taxpayer Advocate, you cannot have worked for the IRS for 2 years before you take the position or 5 years after you take the position. So as I keep saying to everyone inside the IRS, I have no career path here. I really don't care what you think of me. I mean, I would like you to like me, but that's actually immaterial to this. I know what my job is. I will never be coming to you for another job. I don't have to worry about that. And I can just tell you, having been in this, that's an incredibly liberating, protection. A little scary, but liberating nonetheless. And then it talks about that you have to have had experience representing individual taxpayers. So the law makes clear, this is the job description in the Internal Revenue Code. The law makes clear that you have to have been in controversy work before you took this job, so you know what it is like, dealing with the IRS on the other side of the table. And then it also says you have to have some experience in customer service. You have to know, how to work with people. So this is one of the 4 positions in the tax field described in the Internal Revenue Code. And there are only 4, the Commissioner, the Chief Counsel, the Inspector General, and the National Taxpayer Advocate. So right there, that just gives a lot of independence. It also, what the 98 Act did was it took all those little employees in the problem resolution office and by law said they're reporting up to the National Taxpayer Advocate. So they no longer are reporting to the IRS employees. They're reporting directly to me, which eliminates the conflict of interest. And there are all sorts of very interesting provisions in my statute that talk about how I'm supposed to develop career paths for these employees so they don't feel like once they come into the Taxpayer Advocate Service, they have no future. And the law also requires that there be at least one office of the Taxpayer Advocate Service in every single state. So there are 50 states, Puerto Rico, the territory, the District of Columbia. I live in the District of Columbia. I'm very adamant about, we have taxation without representation. My license plate says that. We need a senator and a representative, but that's okay. We'll get there. May have to change the Constitution to get there, but we'll get there eventually. So I now have 75 offices around the country, and those are called local taxpayer advocates. And so there's one, like in states like North Carolina and Texas and Pennsylvania and California, there's more than one office because those are very populous states. But South Dakota has a local taxpayer advocate, Wyoming, Rhode Island. I like to say Wyoming has more cattle than it has people, but we have a local taxpayer advocate for both the cattle and the people. And in fact, cattlemen and women in Wyoming are different from the cattlemen in Wyoming in Montana, and they have different issues because they're dealing with different locales and state laws too. So it makes a lot of sense to have it state by state. I have now about 1,900 employees around the United States. So I actually have a lot of administrative issues too. So with my 75 local taxpayer advocate offices who know what's going on with the taxpayers in their state, Puerto Rico has a local taxpayer advocate, and District of Columbia also has one. The law sets out the purpose of my office, and it's four-pronged. One is the old problem resolution approach, help taxpayers solve their problems with the IRS. And that describes my case advocacy function with my local taxpayer advocates taking the cases in. We have anywhere between 235,000 and 250,000 cases a year that we handle and receive. Those are new cases. So at any given time, we may have more than that, actually, depending on where the inventory. On the really difficult years, we have maybe 300,000 a year. It's varied depending on how the IRS is doing and how the economy is doing. And when my employees work those cases, they themselves don't really have the authority to make any decisions in the case. They have to go back to the IRS employee who owns that case and get them to take the right steps. And that was a big issue when I first came in. My employees felt like because they had been in the problem resolution office, they had been able to just make decisions left and right. But that never changed the employees' behavior on the other side who had created the problem. They never had to learn what was it that they did that caused this problem, or what did they not see was a situation with the taxpayer that they could have done that would have avoided that issue. What issue didn't they address that caused the taxpayer to come to us? And so what we do is we work with theirs, we work with the taxpayer to get the information we need, listen to their position, and do an independent assessment. And sometimes we have to go back to the taxpayer and say, look, this is what we think is the correct answer, or this is what we think we can get for you, because you can't demonstrate this, and I can't go forward and just say it's not fair. That plus the price of a cup of coffee will get me a cup of coffee. It won't get me anything more than that. And so we work with the taxpayer, and then once we're comfortable with what we think is the right answer, and the taxpayer's comfortable with that, we will go forward to the IRS and advocate on behalf of that position, and we will do whatever we can. And in about 75% of our cases, we get the relief the taxpayers ask for. In more of our cases, we get some relief, but it's not necessarily what the taxpayer came through the door with. And I think it's important to track. Taxpayer came to us, wanted X, and we got X. We also track, well, we didn't get X, but we also got Y. But the 75% is that we did get what the taxpayer wanted. My employees, that when the taxpayer comes in, they get one employee assigned to them. They get a toll-free number direct to their desk. And so they get unfettered access to that. My employees might say they get too much unfettered access to them because sometimes it's hard to get their work done. But they do get that. We have a toll-free fax line, so because the IRS doesn't receive emails, which is very frustrating. So people have to fax us, but we wanted to reduce the costs of that faxing so that cost wouldn't be a barrier. And my employees are required to address all related issues. So if someone comes in with an audit issue, but we're also seeing a collection issue occurring even on a completely different year, or we see an audit issue lurking from a year past in the conversation, we found something out. They're supposed to take a holistic view of that case, and the case is not closed until they've addressed everything. And our systems are set up that way so that so that we're able to identify, get a global view of that taxpayer, and then set up an action plan to address all of those issues. And our quality review really looks at, did you actually address these issues? Did you address the audit? Did you also address the penalty that might come out of that audit? Because even if you can't get the audit adjustment done, you may be able to eliminate the penalty. There's just a lot of things. And if the taxpayer ends up with a liability, do we need to work with that taxpayer about a payment arrangement? We're not, the taxpayer's here. Now, the idea was that the taxpayer advocate would provide a model for the IRS. I'm here to tell you that the IRS has gone in the absolutely opposite direction, bifurcating all steps of the thing. So a taxpayer has to go to 5 different contacts, through the whole process. It's very confusing, and that's one of the reasons why we get cases, in fact, because the taxpayer gets lost in between these locations and can't get anybody to pay attention to this aspect of their overall problem. We have 2 categories of cases, well, 3 or 4 actually, but they break down into very simple categories. One is where something the IRS is doing or not doing or about to do is causing economic harm. It's going to cause economic harm to the taxpayer. And that can be low income, middle income, multinational corporation. The first week that I got onto the job, I was approached by IRS Competent Authority, which is the office that deals with countries and international disputes, and said, we have a problem and the country wants to come to you. And I thought, no one told me my taxpayers were going to be a country, but okay, let's just push up our sleeves and find out what this country has a problem about. And I thought, this is going to be a much more interesting job than I even imagined it was going to be. So it can be any kind of taxpayer who comes to us. The second case, that's economic burden. The second group of cases is what we call systemic burden, and that is where the IRS system is not working. The taxpayer's fallen through the cracks. The IRS has said they're going to get something done by a particular time, and they haven't. The taxpayer has tried to go through the normal channels, and the normal channels don't work. And that's important because we're not a substitute for the IRS. We're there to come in. Either there's an economic emergency and the IRS just can't move fast enough to address this, or the IRS is going to go forward and do this economic harm and not listen to the taxpayer, and we have to just come in really quickly. Or the taxpayers really tried and they can't get the resolution they need. We also have a category that I call the taxpayer rights category. It doesn't fit neatly in either one of them, but it really raises some issue of taxpayer rights. The IRS is saying they're not going to give the taxpayer a right to appeal. Well, I believe that the taxpayers have a fundamental right to appeal, and we're going to take that case, even though the normal IRS procedures say the taxpayer doesn't have a right to appeal and there's no immediate economic harm. We're going to take that case. And the fourth category is where I've decided that there's a category of cases that we are going to take on the basis of public policy. And I'll give you an example there. A few years ago, Congress authorized the IRS to use private debt collectors to collect tax. And I know many countries use private debt collectors, and many states do, but I believe that the collection of tax is an inherently governmental function and should not be contracted out. And I disagreed with that legislation, but once it was passed, had to work to make sure that taxpayer rights were being protected. And I was very concerned about how the private debt companies were going to treat taxpayers. So as a matter of public policy, I said any case dealing with a private debt collector, whether they meet any of our other criteria for coming in, they come in. This category of cases will come into the taxpayer advocacy because I want to know how these people are treating taxpayers. And it would give us a body of work that we could see and then make recommendations. So that's the case advocacy function. Then the law says the other prongs of your mission are to identify the administrative causes of those problems that you're seeing, and then identify the legislative causes of those problems. So I have the ability to look at the law, the tax law, and say, Congress, how you've written this, you have the unintended consequence of creating this burden on taxpayers, and they can't get it right. And then the fourth prong is to say, make administrative and legislative recommendations. So administrative to the IRS and legislative to Congress. And I am, in fact, the only IRS employee who can go directly to Congress without going through the Department of Treasury to get permission for my legislative recommendations. The commissioner has to get his legislative recommendations and his testimony to Congress approved before he's able to give it. I just give my testimony to Congress and then hand it over to the IRS and Treasury after I've given it to Congress. And the same thing with my legislative recommendations. Now, that's not to say I don't work with Treasury, but the idea is that Congress, that's another way of building up the independence of the office. And in fact, how these recommendations actually formally get delivered to Congress is that twice a year, I am required by law to send a report to the tax writing committees of our Congress, the Ways and Means and the Senate Finance Committee, without any employee of the IRS, other than my own, any employee of the Department of Treasury, including the Secretary, and any employee of our Office of Management and Budget, which is basically the White House management arm, seeing my report before I deliver it to Congress. And so the report is issued on June 30th, although we'll be late this year, because 2 days ago was June 30th, and I'm here. And then the report is delivered on December 31st, but since no one's ever around on December 31st, it usually comes out the first or second week in January whenever Congress comes back from its winter recess. And so that is in those reports are where I identify the issues I'm looking at, describe the problems I'm looking at, make my administrative and legislative recommendations formally. The December report is by far the biggest one, and big is actually the operative term. It's usually about 600 to 700 pages long. It's quite an undertaking, and I am required by law to identify at least 20 of the most serious problems that taxpayers have. I will say that for the last 5 years, international taxpayers have factored very prominently in my identification of the most serious problems. There was 1 year that we made the large business and international operating division of the IRS totally paranoid because we had 6 most serious problems that were all about their taxpayers: International Taxpayer Service, FBAR, FATCA, on and on and on. And they weren't happy having to respond to those because they're required by law to respond to me within 90 days of my making these recommendations. In my June report, we publish the IRS responses so that you see this transparency. You see our identification of the issues in the December report. Then in the June report, we publish the IRS responses and whether they accept our recommendations or don't. And theoretically, there are reasons for them. And then we have our response saying what we're going to do, whether they've accepted them or not. We just tell the world what we're going to do. With our legislative recommendations, we publish every year the list of legislative recommendations that have been adopted and also have been dropped by senators or congressmen and women at least as bills. Our Congress hasn't been passing a lot of laws lately, if no one's noticed, but they have been introducing a lot of legislation. And I have gotten about 16 pieces of legislation actually enacted into law, which is a pretty darn good rate. It's about an 11% rate over our recommendations. I think there's some senators that would love to have my, enactment rate. So many of them are common sense. It just takes a while to get them through. So that's sort of so let me talk a second also about the taxpayer assistance order, because I think that's very important. The taxpayer assistance order is also in the law. So my code section of Title 26 United States Code is 7803C. And that's what just describes my office. And again, I serve without a term. The secretary can ask me to step down, but I've been in this job now this is starting my 15th year. I do tell the story that I was appointed on, I think it was January 12th, 2001, which was 8 days before the Clinton administration left, and Larry Summers signed my appointment certificate. But I showed up at work on March 1st, and Paul O'Neill was the Secretary of the Treasury, and President Bush was the new president. So before I'd even shown up on the job, I had somehow worked under 2 different presidents and 2 different secretaries of 2 different parties. And I've made it through 5 commissioners and 3 acting commissioners and 5 Treasury secretaries, and again, 3 presidents, I guess you'd have to say. So, it really is a bipartisan office, and we are viewed on the Hill as nonpartisan, and we guard that very, very fairly. We get everybody at some point angry at us somewhere along the way, and everybody at some point desperately needs us to advocate on an issue or needs our support on an issue, and I think it sort of balances out. The Taxpayer Assistance Order is this statutory tool under 26 U.S.C. 7811, and it gives the National Taxpayer Advocate, and then I've delegated it down to the local taxpayer advocates, these people who head our local office, the authority not just to order the IRS to not do something like don't do a levy or stop levying, but orders them to do something. So, make this adjustment, give this person an appeal. And so it's to stop doing something, not do something it's about to do, or do something. And we can also, by law, set the date certain. You have to do it by this time. And we're able to do that where the taxpayer's experiencing a significant hardship. And those buckets of cases that I described, economic burden, systemic burden, taxpayer rights, that is all within the definition of significant hardship. And so what we're able to do is order the IRS, and then if the IRS disagrees, if it starts at the lower level, at the local taxpayer advocate level, they can appeal it. But once it arrives at my desk, and it really only takes 2 steps, the IRS appeals it at the local taxpayer advocate level, there's an intermediate management step, and then it lands on my desk. So it doesn't take very long for a taxpayer assistance order to get to my desk. I want a very shallow management structure. I don't want lots of layers between me and my frontline employees and the problems that taxpayers are having. And when it gets to my desk, if I order something, only the commissioner or the deputy commissioner can overturn my order. So if I'm ordering it, the IRS cannot do anything while it's being decided at this level. Now, there's a little debate right now because the law says only the law says only the National Taxpayer Advocate or the Deputy Commissioner or the Commissioner can overturn an order that the National Taxpayer Advocate issues. And there might be some time where I'm overturning my own order, but I'm not sure quite what that means. But I believe that I should send it first to the Deputy Commissioner to see if the Deputy Commissioner will get it right. I want to work through the management chain. The commissioner maintains, because he's presidentially appointed, that he does not get involved in individual taxpayer cases. I have a little bit of weirdness about the fact that I would be ordering my boss to do something. That's sort of a little weird. So what I was saying was once the deputy commissioner makes a decision, I will elevate his decision to you with a memo and say, please review this because I disagree with his decision. And in that way, I wouldn't be doing the disrespectful, I'm ordering you, boss, to do something, but I would still get it to his level. Now, this commissioner has said that he doesn't believe he should get involved in cases. So I have had the occasion to go into him saying, I know you don't want to get involved in cases, but here's this memo and I'd like you to look at it and blah, 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 blah. So we're working this out. My advice to the IRS is they really need to accept my way of my proposal about how to deal with this, because Congress is eventually, as it has done in the past, going to come in and tell you how it's going to be done in the law. And it's going to be a lot less favorable to you if I'm having to go to Congress saying, I have these cases and the commissioner's refusing to look at them. They're going to say something to the IRS that I will not lose in that battle. The National Taxpayer Advocate is sticking up for the taxpayers. The taxpayers will not lose in that. So why don't you work with me here and come up with a procedure? So here I am 14 years on, and we're still dealing with these kinds of tensions and issues. So I'm not sure what else you would like to know just about there's another tool that I have that is created by administratively, and we have recommended that Congress codify it into the law. It's a little bit like the Taxpayer Assistance Order, but it's called the Taxpayer Advocate Directive. So the Taxpayer Assistance Order goes to specific cases, whether it's a business or an individual. It goes to cases one-on-one. Do this in this case. But with the Taxpayer Advocate Directive, I have the authority, and this cannot be delegated down to anyone, to order the IRS to do something or stop doing something or not do something with respect to a group of taxpayers or with respect to a procedure that impacts a group of taxpayers. Or to all taxpayers. So I can say, do not implement this program because the way it's designed is harmful to this group of taxpayers in this way, and you need to fix it in this way. And again, it's my order, so it stands until the deputy commissioner or the commissioner overturns that. So I can stop things in their tracks. Now that, I think, needs to be put into the law because it's a very important tool. And actually, there is legislation in the works right now that is going to introduce that into the law. So I think that that's very interesting. The one thing that isn't in the law but has turned out in practice, and it would be something that I would fix in the law, is that the Taxpayer Advocate's budget is within the IRS's budget. And so one of the commissioners that I served under had decided that he wanted to shrink the Taxpayer Advocate Service budget, wanted to build up enforcement and shrink Taxpayer Advocate Service. And he also wanted to cut taxpayer service, and that made Congress very upset. So Congress came to me and said, what is the IRS doing about taxpayer service? And I said, well, they're cutting it, and they're also, and they said, well, what are they doing about your budget? And I said, they're cutting my budget. So that was the year that they asked me to testify about the IRS budget, and this brought the appropriations committees as opposed to the tax writing committees into my office. And it was a little uncomfortable because here's the commissioner sitting here on the panel, and I'm sitting right there, sitting next to my nominal boss, and he's saying what he thinks the IRS needs, and I'm saying what I think the IRS needs. And I thought, well, this is interesting. And that was also the same year that my boss tried to fire me. What happened was that in the appropriation law, Congress wrote in a set-aside within the IRS budget for my office. So now every year since the fiscal year 2006 appropriation, there has been a set-aside saying within the IRS budget, no less than X amount of money shall be allocated to the Taxpayer Advocate Service. So our budget can't go below a certain amount. And that has been an incredible protection for my office. And again, that goes back to, the IRS does something and then Congress gets wind to it and then inserts, and it's just like, if you'd just worked with me, folks, we wouldn't. And every year the IRS and the White House put forward a budget that doesn't set out our budget. And every year Congress writes it into the law, and you'd think after a while that they'd get with the program, but no, they're not there yet. So that's how they deal with the budget, and like I say, that's very protective. So maybe I'll stop there. I've testified before Congress. I counted it up the other day, over 60 times. That's sort of a record, I think. It's a lot of testimony over the years. Some of it's just a result of the longevity. I've done it 3 times so far this year. So one was written testimony, twice were appearances. So there we go. Questions on that? Yes?
What happens if you order the IRS to do something or not to do something and they refuse?
They refuse regularly. I will say, what happens is that we threaten the order a lot more than we actually have to issue an order. We're now ordering, of my 75 local taxpayer advocates who have that authority, last year they ordered about 400, and they actually issued 424 taxpayer assistance orders. Most of the time, in most of our cases, we just send over to the IRS, look, here's the information, look at it. We ask them, pretty please, do what we're asking you to do. And most of the time they do it. So when they won't do it, you already have this dispute. And then you threaten, politely, but you say, okay, I'm going to have to my frontline employee, my case advocate who's actually working the case, will say, I have to elevate this now to my local taxpayer advocate, who's going to talk to your manager, IRS employee. And saying that just miraculously solves so many problems. The idea that a manager would start looking at what you're doing, nobody wants that. So then they will say, oh, well, maybe we can find a way. Let me think about this again. We have actually decided that we're going to start tracking how many times we threaten a taxpayer assistance order just to find out what the impact of that is. But then even when they say, well, go ahead, or we have the conversation with the manager. And unfortunately, we're seeing that more and more as the IRS budget gets, cut and cut and cut in the IRS, in the United States budget situation. And the IRS, last year's budget was shrunk by, with counting inflation, between 2010 and fiscal year 2015, there has been a 17% real cut. And this coming year, it's about an 8% cut going into next year, which I don't even know how we deal with an 8% cut in 1 year. It's huge. And so the IRS's response is that they're not being responsive. They're not being responsive to us. They're not being responsive to taxpayers. Everybody's overwhelmed. And they don't want to talk to anybody. They just want to get through their work. And getting through their work means they get the wrong answers because they're not talking to anybody. So we're seeing more that we can't get things resolved at that second level and that we have to issue a taxpayer assistance order. And when you do that, they're not easy issues. Maybe about 50% of them, you look at them going, why wouldn't you get an answer to this down at this level? Why are you digging your heels in? But the other ones, we're saying to the IRS, your existing guidance is wrong. I've got this guidance over here, and I've got a taxpayer over here that has different facts and circumstances, and you don't have anything out there, and you need to look at this taxpayer in light of their facts and circumstances. And they're saying, well, they don't meet our requirements. I'm like, well, I know that, but you've got new facts, and I really don't care what your guidance says. It's not the law, and we need to go up to the law, and we need to apply the law to the facts of this taxpayer as we find them, and this is what you have to do. And people down below don't want to make that decision. So a lot of times it takes me getting to the head of office, like the head of Large Business International, or the head of Small Business Self-Employed, that oversees all those employees, to say, you need to make a policy decision here. And sometimes I have to call in counsel and say, is there any legal prohibition for you doing this? And they'll say, no, it's a policy call. And that might take months. We have an issue right now that I've been working on since 2010. It is one of the most appalling things that I've ever seen the IRS do. It deals with taxpayers who are victims of return preparer fraud, where the tax return preparers have stolen their refunds. And the IRS has been saying for years, that the taxpayer just has to go against the preparer and sue them in state court or something to get their refund back. And it's just like, no. You know, when the taxpayer's identity has been stolen, you pay that money out to the identity thief, but you also give the taxpayer. Why aren't you doing it here? And the IRS has known since 2003, when our counsel first opined, saying there's no legal impediment to giving out a second refund. And the IRS has refused to do this. They were told in 2010, in 2011, and in 2012 by counsel. We got legal opinions in each of those years, and the IRS refused to do it. I have issued taxpayer assistance orders. I have issued 3 taxpayer advocate directives on this case, whittling it down, and the IRS will say, oh, well, we'll do it in this instance, but not in these instances. No, you will do it in these instances. I have sent these cases out to the low-income taxpayer clinics that are receiving these grant funds now around the country to litigate. And it was just 2 weeks ago that the IRS finally sent us some draft guidance doing what I had ordered them to do, you know, I don't know, back in 2010, and what counsel said they were allowed to do back in 2003. And ironically, what they did was they said, well, we'd like you to look at this guidance and give us a response back in 3 days. And I was like, you know what? You've had since 2003, you know, to get this done. You are not getting this back in 3 days. And, you know, you are not moving forward with this until you hear back from me. So we have a lot of concerns about it, but that's sometimes, and we have, you know, there are 1,000 cases or so wandering around with this issue. And these taxpayers have refunds waiting for them from 2008. We have taxpayers who have actually, they went to the Criminal Investigation Division of the IRS. The Criminal Investigation Division took their testimony, referred it over to the Department of Justice. The Department of Justice prosecuted the return preparers. The taxpayers were witnesses in the trial, and the return preparer is serving time. And yet the IRS will not give this taxpayer the refund that we know this preparer ripped off on them. And I don't know how you comport that with due process or anything like that. That's what the litigation would be all about. But we may be able to avoid litigation. So that's one of those ones where what I do is I just write about it, I speak about it, I talk to Congress about it, I do all sorts of stuff. I think that part of the thing about where the IRS says no, we've had a lot of instances where the IRS has said no in the beginning, and then after about 4 or 5 years, when they've tried everything else and none of that else has worked, they come back to our recommendation and they try it and it works. And, you know, I've said in some of these things like, okay, now your pattern here is that you do everything else and then wait 5 years and then do, so we're making some recommendations this year. Can you not wait 5 years? Can you just try our recommendation, please, so we can get all this stuff in between out of the way? But I think it's just that they have to have a process. They're very slow, they're very conservative, they don't like change. And we may be saying, you're thinking about this all wrong. And you've got to do a paradigm shift. And it takes them a while to do a paradigm shift. So you have to have a lot of patience in this job, and you have to not give up. And I absolutely do not give up. I mean, I'm very, very stubborn. I have to feel like I want to be open to know that I may miss something, and that's why it's important to have that dialogue with the IRS. Is there something that is really causing them to say no? It might be that then I'd say, well, explain it to me, and then I go, oh, okay, well, I understand why what we're recommending wouldn't work, but how about if we did this? Would that accommodate your concerns, but we could get a solution? If I don't have that dialogue, you know, and that's why being inside the IRS is very helpful, you know. Even if it's not in a formal environment, in an informal environment, sometimes I can find out what's really driving them saying no. And you know, it's funny, there's not a day, as true today as it was when I walked through the door, there is not a day that goes by that there isn't a meeting in the IRS somewhere, in the big IRS somewhere, where somebody says, and don't tell the National Taxpayer Advocate about this. And there is not a day that within 30 minutes I am finding out about this. From someone somewhere, somebody has said, okay, you know, they tell one of my employees down there, and then I get the email saying, you know, they discussed this in this meeting, and that lets me go down the hall and go, I hear you're talking about this, which is really a lovely feeling to have sometimes, just to see people's faces. You know, it's just one of those little wicked pleasures in the jobs. And you'd think people would learn after 14 years that the IRS is a sieve, and you're going to find everything else, about it, but people don't learn, so.
We only have 2 minutes left.
Oh, my
so
goodness.
Maybe one last question.
Yes?
Yeah, it's a short question, but I think it requires a long answer.
We need to get the microphone to you.
Oh, sorry.
So they can pick it up.
There is a large constituency of Americans residing abroad, and I don't know if they have a voice. When you talked in terms of structure, you talked in terms of the states, the district, but
Yeah.
you have Americans residing out.
Yeah.
What is the appropriate avenue for them?
So first of all, I have attorney advisors on my staff who really are very knowledgeable about the international issues and feel very much like they're the advocates for the international population. And a lot of the organizations that deal with citizens abroad or U.S. taxpayers abroad come to us, and they have my attorney advisors' emails. We also have our Puerto Rico office handles our international calls. And we have been really trying to get the IRS to get us online, let us at least for the international taxpayers be able to receive emails from them. It's not a toll-free number, and that's not our choice. I've actually asked them to look at Skype. The U.S. Embassy uses Skype. It's just like, or Vonage or something like that, so that you could have these inexpensive calls that people could really communicate. We have made a legislative proposal. And again, it's in my report this year, and we will have a very detailed discussion of it in my June report when it comes out in mid-July, about establishing taxpayer advocate offices abroad. And we actually have a map showing where our cases have come from over the last years and what countries they've come from. It's very interesting. The most common is Israel, which I just wouldn't have guessed it. That was very interesting to me. Canada's right up there, but Israel, like what? So that is, I've tried to think about how can I need to figure out how to get them established if the IRS won't apply. Do I have $4 million somewhere that I can give to keep these offices open? And unfortunately I didn't. But, so our thought was, we need to be over there at least doing the outreach. Can we establish somebody in Canada? Can we establish somebody in Mexico? Can we establish somebody where you would have different countries aligned to it? And we were actually thinking Africa, the European continent, certainly looking in Asia, where would be the right place, whether it was China or Japan or wherever it needed to be. So stay tuned. I'm not giving up on that. And I will give you right now my email address. As you get problems, please email me. Do not send any specific taxpayer information in that email, but describe the problem, and then I can get somebody on my immediate staff to call. And if you have a case, we can get it assigned to a case advocate and get it resolved. And again, it's business, it's individuals, it doesn't matter. We take our taxpayers, they're all types. So and this is my actual email, Nina, Nina, .e.olson, and it's Swedish derivation, so you spell it with an O, O-L-S-O-N, @irs.gov. Nina, Nina, .e.olson, @irs.gov. And I really do respond to my emails. It just might take me a while, but I don't ignore them. Read our annual reports, because we have really been writing about FBAR and FATCA, and we have a big piece on FATCA coming up in the June report. We've made legislative recommendations, we've made administrative recommendations. Going back to 2009 and the original Offshore Disclosure Initiative, I always shoot a taxpayer advocate directive about that because I believed it was so poorly designed. It took them 3 years to adopt some of my recommendations, and they have slowly and been changing the procedure to adopt some of my recommendations. My problem with it is it started from the wrong assumption. It started from the assumption, as most tax administration starts from, which I think is completely wrong, that most taxpayers are non-compliant. You know, that you've got people who are trying to cheat as opposed to the vast majority of taxpayers at least willing to comply with the laws if they can figure out what they are or they know what they are. And so the process was designed for the people who they thought were the worst actors possible. And then you have the vast majority of the taxpayers trying to fit into this, and it doesn't fit. And as I've said in my talks, even going back to 2009, I mean, they set up a system that terrorized the entire country of Canada. So, you know, it took them a while to come up with, okay, well, this is what we're going to do here for you all with your qualified retirement accounts and things like that. But it's based on a wrong premise, and you can tinker around the edges. They will never throw it out completely, which is what I think they need to do and start afresh. But they're much better off than they were. But I think the problem is where they come from, and I will continue to say that. And we have our cases, and so if you have cases where you're caught up in these things, certainly bring them to us. I have very skilled staff, and we have been successful in some pretty contentious cases that have taken a long time to resolve, but we have not given up. So that's our story. I'll stay around if people want to chat.
We have actually, we put in the schedule till 9:15, so if there are any questions, feel free to.
Oh,
leave
good.
on the evening.
Great. You have, yeah.
Yes, well, I have a question regarding maybe, you mentioned the IRS using fax, and do you think that IT could solve some problems with that the taxpayers experience?
Well, you know, the IRS really wants to go in the digital direction. And I think being digital is very important. You know, the United States is one of the few, if not the only, large tax administration, developed tax administration that doesn't have an online taxpayer account. And we're so far behind in IT in that way. And the IT budget being cut doesn't help get us closer to that. But that is the direction that the IRS wants to go. My concern about that is if you read where the IRS describes its vision of the future, they keep talking about being like airlines. And I keep saying to everybody, I don't think airlines are a model of how you want to relate to your customer. And when I have a problem with an airline, I want to talk to a live human being, you know, and say, you make sure that I'm okay through here. And so for maybe a whole bunch of activities, digital is great. But when I have a problem, the kinds of things that, you know, and I want to know that the IRS is doing what it says it's going to do. And I want to hear back that it's being done. And I'm very much afraid that what they're focusing, you know, that they're really trying to move people to digital, and that they're getting away from that interpersonal contact, so that you will hear what the taxpayer's issues are, you will respond to that, and you will have to articulate what you're doing. And I think it removes ownership of issues and accountability from the IRS employees. They're hiding behind this digital screen. If you look at the literature on procedural justice, you know, trying to get people to partner and cooperate with power as opposed to being in the adversarial relationship. What you find over and over again in empirical studies, whether you're talking about police or you're talking about the courts ordering people to do something and people obeying those orders, like in family law and everything, is that partnership, is that engagement together. And, you know, if it comes in from on high, like an email or something, and there's no dialogue, you know, you're not getting that engagement. So I think we have to be very careful. There are very great efficiencies and ease to come with digital, but it cannot come at the expense of the engagement with the taxpayer. And the other thing I'm worried about too is that over time, I think what will happen if we go down this road without thinking carefully is that the only time the taxpayer will have any one-on-one interaction with the tax authority is when we're doing something bad to them. We're taking money from their bank account. You know, we're seizing their assets. And what is the relationship with that taxpayer at that point? I'll tell you a little story that just happened this week. in my actual office, I was standing by my staff assistant, and my executive assistant came up and said we had 8 Federal Express envelopes that had come in that morning. And the only thing that was just addressed to the IRS at its headquarter buildings in Washington, D.C. And whenever nobody really knows where to send the mail, they send it to us if it doesn't have a name on it. So we get lots of really interesting mail. And in these little overnight packages was just a receipt of a deposit slip at a bank. And it was for $5,817 in each of these 8 envelopes. There was a scam going on where these people called up taxpayers and told them that they were from the IRS, they owed $5,817, and they had 3/4 of an hour, 45 minutes, to get to this bank and deposit this money, or the sheriff was going to come to them and arrest them. And we talked to a few of the taxpayers, and then they were told, once you've made this deposit, put it in overnight and send it to the headquarters of the IRS, which I thought was fascinating, like to make it legitimate. And they even said, you know, I'm from the IRS, you know, call us back. So they had the taxpayer call them back. They had picked up all these little traits to sort of avoid against scams. And we thought, you know, this is awful. I mean, it's just awful. And we alerted the criminal investigation. We alerted justice, you know, about this particular scam so we could get word out about it. But I really had to stop and think. We live in the United States today where at least 8 human beings thought the IRS was capable of calling you and saying, we just assessed this tax, we've sworn out a warrant for your arrest, you have to make this payment in 45 minutes. What does that say about how people view the IRS? You know, and that, I just, you know, I'm still working on that one. That's a big issue for me. Scary. Tragic.
Can I ask you something?
Yes.
Not only, you know.
Microphone.
You know, when you get a letter from the IRS and you are a non-resident of the U.S., all the phone numbers, anything on there, do not work. You have to write a letter, which, if you're lucky, you get an answer back in 6 months. In the meantime, your clients are receiving, by the way, my client yesterday got delivery of something that only had her name and Montreal. The Canadian Post Office is a miracle. They found her. And it didn't have her street. It didn't have her apartment number. Anyway, the point I'm making here is this is like a bizarro situation for anybody who doesn't happen to live in the United States.
Well, you have my email address. You can, that's a systemic case, if not an economic burden. And you can get to us and we will track down and get the IRS to pay attention to that issue.
Okay,
I mean, seriously, you know, what has happened with the IRS budget is that this past year for the filing season, you know, from January 15th to April 15th, the level of service on the phones, for taxpayers trying to get through to a live human being, was 37%, which means fewer than, you know, basically slightly more than 3 calls out of 10 that wanted to get through to a live human being got through, and you had to sit on hold for 24 minutes. And if you're calling from South Africa and it's a toll call, just give up. I mean, there were lines where it was 11, the level of service was 11%. Basically, 1 out of 10 calls got through. And there are just not enough human beings answering those calls, and they're disconnecting a lot more people. They have something called the courtesy disconnect. You get a message saying, thank you for calling us, we can't handle your call right now, clunk. And they've done it a lot earlier in the system because they don't want people to wait for an hour and then get the courtesy disconnect, but you may also get the courtesy disconnect after you've waited an hour. They use it though at the upfront. This is one of the most serious problems. It has been the most serious problem for taxpayers. It's this battle that the IRS is in right now with the Congress. They're very upset about how we treated nonprofits, political nonprofits, and sort of some of the way that the IRS is spending money, so their theory is to withhold money from us until we can prove that we spend it wisely, but the taxpayers are being harmed. And that's why, you know, and then the same people who answer the phones are also the same people who process the mail. So if you move people from the mail, then the phones get behind. I mean, you know, if you move people from the mail to the phones, you get caught up on the phones, but the mail gets behind. If you move people from the phones, then you have to wait a really long time. And it's a mess on either side. And what the taxpayers do, they can't get through on the phones, they keep calling and calling and calling, and then they send a letter, and then the letter doesn't get answered, so they call again, and then they send another letter, and the first letter hasn't even been answered, and then you've got a second letter. And then when you do get through, the IRS assistor can tell that you've sent a letter, but they can't see the letter because it hasn't been put on our system because we're behind. It is abysmal. I have never seen anything like it. That's what we're saying in our June report. We're actually using Dickens in our June report. You know, it's the tale of two cities. We got through the filing season with the Affordable Care Act. So maybe that was the best of times, but if you were a taxpayer and needed to talk to the IRS, it was the worst of times.
Why is it that you cannot use email? I don't understand that.
The IRS IT people say that they don't yet have the system secure enough. How taxpayers should authenticate, and how to wall off email from the rest of our data, which is so important. Now, why other countries are able to do this, I don't know. The IRS is doing a pilot. They were supposed to start it last December. It's been pushed back to starting this December. My folks will be part of that pilot, and we are trying to advocate that international taxpayers be the first group where it's rolled out to so that they can communicate by email. But it'll be a very clunky thing, like you'll have to download a product and sign into it so that you're working in an encrypted environment. So I wonder whether some taxpayers will be able to do, and you have to authenticate yourself, and maybe you can, maybe you won't. So we'll see how this pilot works. I don't, people say to me, oh, it's security, and I don't have the skills to be able to say to them, is this true or not? I can only tell you what they say. It's very strange to me. And we have criticized them a lot about the online experience. One thing I want to say is that in November 18th and 19th of this year, we are having an international conference on taxpayer rights in Washington, D.C. And Allison Christian from McGill is going to be on one of the panels. And we will have people from all over the world coming to talk about taxpayer rights and the role that they play and how tax administration could be designed, a lot of concepts about procedural justice and things like that. So I'll get that information to you, and you can get it out through the Tax Foundation, and registration will be available if you want to come down to Washington, D.C. It will be fun. It will be held in the archives, and that's a really interesting building, and you will be able to see the Declaration of Independence, the actual one, and the United States Constitution, and one of the Bills of Rights, and we have a Magna Carta. So that is an incredible document to actually see the physical, one of the few extant physical documents with the seal of King John still attached, which is really darn neat. And so that's very fitting to have the Taxpayer Rights Conference there. So.
Great. We'll wrap it up.
Yes.
Thank you very much for being here today, and we look forward to hear from you soon.
Okay. Thank you. All righty then.
Sorry about that.
No.
I had 9 o'clock.